Hello, and thanks for watching. My name is Teresa Hanna, and I'm here with you today as a member of the Generosity Ministries team. Our team is charged with supporting the financial viability of the fellowship. Part of that work is building awareness of and encouraging donations to the fellowship's endowment. Fellowship supporters who have donated to or remembered the endowment in their estate plans become part of our Acorn Society. That name was chosen from a Nelson Henderson quote. The true meaning of life is to plant trees under whose shade you do not expect to sit. 70 years ago, a group of visionaries formed the fellowship, and we have watched it thrive ever since. Like those before us, we now have a responsibility to continue the mission of our religious community into the future. Please consider a donation to the fellowship endowment. If you have questions about our fund, please contact Fellowship Director of Finance and Operations, Phyllis Schmidt, by emailing phyllis@fvuuf.org. We've created a couple of videos to answer questions from our members about estate planning and funeral preparation. The following video includes answers from Attorney Joe McClear of McClear Law, LLC. Joe's practice is exclusively elder care and estate law, and his office offers a free initial consultation. We'll share his contact information during the presentation.
We have several questions about the basics. When do I need an estate plan? Why do I need a secondary guardian for my dependent children? Can you tell us more about the fundamentals and what we should think about when we're just getting started?
Okay, so there's a lot there, but as far as when do you need to do an estate plan, the professional answer would be as soon as you become a legal adult at 18. Nobody's really doing that. Realistically, there are 4 times you got to make sure you either get or update your estate plan. 1, most important, when you have minor children. 2, when you get married. 3, when you buy a house. 4, when your estate, even if you don't have a house, is at least $50,000, when you have at least $50,000 in assets. As far as secondary guardian, well, you nominate the primary guardian, but maybe, hopefully, if there ever need to be used, it won't be for a long time. Things can change. The primary guardian that you nominate may not be the best person to take care of your kids at that point, or they may not just be able to do that. So you should have at least one backup. And as far as the basics for estate planning, here's what you got to know. You're going to die. You're probably going to have stuff. You can control what happens to it after you're gone. The presumption is everything is going to go through probate, which is the court proceeding. That takes a while, takes about a year, but gets the job done. You can control how it happens in probate with a will. That's what a will does. That's also where you nominate the guardians for your children. If you don't have minor children, though, you can avoid probate, you can avoid the courts. That's what trusts do. That's what trust-based planning can do for you.
What is probate? If a family member manages the settlement of an estate, is there any governmental oversight that the estate plan was carried out per instructions? What is the approximate cost of having an attorney execute an estate plan? Last, do pay upon death accounts avoid probate?
So probate is the court proceeding that every state has used to make sure that your final debts are paid, your final taxes are paid off, and your estate is distributed, either in the manner that you wish if you had done a will, or in the manner that the estate already predetermined for you if you don't have a will. So if a family member manages the settlement of the estate, which is fairly common, is there oversight? In probate, absolutely. It's normally going to be a court commissioner who makes sure that the personal representative, which used to be known as the executor, is doing everything by the terms of the will. Or if it's a contested probate or a formal probate, it'll actually be a judge. Ideally, it'll be an informal probate, and it goes a lot smoother, and that'd just be a court commissioner. If you have a trust-based plan, it would be the beneficiaries of the trust who can provide some oversight on what makes sure that the successor trustee is carrying out the estate according to the terms of the trust. Now, the approximate cost of having an attorney execute an estate plan. Now, there are 2 avenues to that, because you can say execute as in form the estate plan, or execute as in administer the estate plan. It's 2 different animals. To form the estate plan, it's going to be a wide range depending on if you have a will-based estate plan or a type of trust. It could be a couple $100 to several $1,000s. For after you're gone and you're probating an estate or you're administering a trust, it's usually going to be somewhere in the realm of 1 to 2% of your estate value. So it can vary depending on the size of the estate. And lastly, the question was asked, to pay on death avoid probate? So payable on death is what it's called, POD. They also have things called transfer on death, or TOD, and those do avoid probate, assuming you did it right, and assuming whatever your financial institution still has that documentation. I always recommend every couple of years, review your estate plan and review your plans that you have with your financial institution, banks, insurers, and whatnot, to make sure that they still have that documentation, because sometimes they don't. But yes, they do avoid probate if they do it right.
Hello. I'm interested in knowing what kind of information I should give to my children who will hold power of attorney, or what information I should get from my mother for whom I will have power of attorney. I remember very well my sister-in-law not being able to access her deceased husband's laptop because she didn't know the password, for example. So if there's some kind of list of things we should know, that would be great. Thank you.
So we're assuming that everyone's of sound mind in this equation. You should let your family know if you have nominated them as your power of attorney. Maybe that's all you need to let them know, other than, in the event of an emergency, where can they find the information they need to help you out? Where can they find the power of attorney document or your estate plan? Where can they find a list of where your assets are, which banks you work with, where's your insurance, who holds your retirement accounts? And yes, you should have a list written down somewhere, probably all in the same place, with your internet passwords. Okay, that is a big problem that people, even husbands and wives, can come upon. So you don't have to tell them all this in front. You don't have to give them the power of attorney document. You don't have to tell them right now where all your money is or what your passwords are, but you tell them where they can locate them in the event of an emergency.
How does a direct contribution from an IRA to a charity avoid taxes? How does a charitable gift annuity work? Is there a specific way to name a charity as a life insurance beneficiary?
Yes, many people leave gifts to charity in their estate plan, their will, or their trust. I do it quite frequently. I encourage it for folks who do not have minor children. If their children are all grown up, they're out in the world, they're making their own lives, making their own money. Sure, you want to still take care of them, but now would be a good time to consider helping out society in general as well with charitable giving. So is there a specific way to name a charity as a life insurance beneficiary? Yes, first of all, I would say talk to the charity first, because they may have a specific fund that they would prefer you to name as the beneficiary, or a specific side group that would be their fundraising arm that you would probably want to name. Then you talk to your insurer, and you fill out a new beneficiary form, and you leave a percentage of the benefits to that charity. It could be 10% of the death benefits, 50%, 100%. You don't have to leave the whole thing. You can split it up between your family and the charity, and you do it by percentages. Now, here's another point, though. It's actually smarter if you have a IRA or pre-tax retirement account, so everything that's not a Roth. If you have that as part of your portfolio, it's smarter planning, estate planning, and tax planning to leave a portion of your IRA to the charity. Because if you were to leave the IRA in total to your family, they're going to have to be paying income tax on it when they take it out. If you were to leave some or all of your IRA to the charity, though, they're not paying any income tax on that. They're exempt from paying income tax. So yes, you can leave a portion of your life insurance to the charity, but if you had a choice between leaving a portion of your life insurance and a portion of your IRA to the charity, pick the IRA, and you'd be saving everybody a bucket load of taxes. I'm very happy to be included in this presentation. If you have any more questions about estate planning or elder law, you can schedule a free no-charge initial appointment with McClear Law Office at my office. by calling the office at 920-221-0320, or you can set it up by visiting my website at mclearlaw.com.